Hello, IP friends. It's been a minute. Welcome back to my podcast, IP series with Rita. My name is Rita Anrichinda, and I am the podcast host. Now, if you have not checked out the previous episode, Ejo, Mbok, Biko, help me. Just listen to it. I talked about the possibility of an intern earning or being credited or acknowledging that they created an intellectual property work in the course of their internship. So check that episode out and let me know what you think. Meanwhile, if you're a first-time listener, I talk about copyright, trademark, patent, industrial design, trade secret, and plant variety, giving it like an African fusion, Nigerian fusion. So I review cases, I talk about trends, and any other thing that is intellectual property related. For my returning listeners, you guys already know the drill. Thank you so much for coming back. Don't forget to like, share, subscribe, favorite on any of the platforms you're currently listening to me. I'm on Instagram at ipseries_with-reader, Twitter at ipseries1, Facebook at ipseries. So let's get into our conversation for today. I do hope that my IP friends have enjoyed the previous episodes of the IP series Christmas edition for this year, and today I have another guest with me who will be discussing trademark. Why do you need to do a trademark? What's the process for trademarking, and several other things. So let's welcome our guests and get the conversation started.
So, welcome guys to another episode. I have a guest with us today. His name is Derek. Derek, can you introduce yourself and tell us everything we need to know about you?
Hello, good afternoon. My name is Derek. I doubt if this time is enough to tell everything that needs to be known about me. But for starters, my name is Derek Nduka-Edede. I'm a lawyer. I'm near in law practice, particularly general practice, and then with particular specialty in business law, intellectual property, entertainment, and sports law. So in a nutshell, that's it.
So, Derek, you mentioned about intellectual property. So let's say someone wants to do a trademark application.
Okay.
What would and the person doesn't really know what trademark is? What is trademark? If you want to explain it to a layman.
Okay. Um, to simplify what trademark is, I would simply say trademark is an identity you give to your business or your brand to make it stand out in the line of business you're doing. Every human and given a name that differentiates it from other people. So when you hear your name, you are identified by it. A trademark is a name or a brand, is either a name. I was simplifying it by saying that a trademark is a name, an image, or a symbol to identify your business with that distinguishes it from any other business in that same area.
So how did you become a trademark agent?
Well, I started reading up in the area um, from reviewing um, intellectual property disputes and then reading up on what trademarks were about. I began getting interested, and then of course started getting research questions in the area. And then by the time I started reading up and asking questions, I found out that it was important for businesses and brands to have that protection. And then that piqued my interest. I became a trademark agent through research for starters. I had read an article about intellectual property. I think it was a dispute on a trademark. And so in the author, the processes involved in registering trademarks in both Nigeria and in the jurisdiction the case was discussed about. And then from there, I just started gaining interest, reading material on trademarks and intellectual property, and then started asking questions from, you know, people who were working in the Ministry of Trade at the time. And then that was how I got it.
If someone like me or any other person wants to become a trademark agent, other than reading up about it, is there like a formal registration or exams we have to take to become a trademark agent in Nigeria?
There's a formal requirement for it. It's on the um, intellectual property platform where all trademarks are filed, the ipo.nigeria.com. I think that's the website. That's the website. So there's an option where you see become an agent. So that you can either register as an agent or register as an individual. What happens? Register as an agent or as a corporation or as an individual is different because when you register qualified, you're a professional because you'll be required um call to bar, what's it called? Supreme Court enrollment number, yes. And then your year of call, you're expected to register as a lawyer if you're registering as an agent. That way you can file marks on behalf of other people for clients. You can also register as an individual. It means yes. So the between the individual registration and registering as an agent, it requires the same thing for an individual except for requests demand your enrollment number.
Record.
The idea is that you're registering for yourself to file your marks in the future, knowledge around intellectual property. But agent, you're expected to put in your details as a lawyer or your enrollment number. I think that's how you become an agent on the platform. A while ago, there used to be a fee to register as an agent, but as at 2000, they remodeled the platform, and now agents, particularly lawyers, can register for free.
Fantastic. I guess that's good news for lawyers then. So my
Yes,
next question would be so my next question would be what are the common mistakes that you see clients make when registering a trademark?
um, it's interesting you ask this question because most times clients, without very good understanding of trademarks, and of course, the responsibility is on the lawyer to inform the client because most times these clients have zeal. I think what they see is their brand. It's left for the lawyer to properly so that they don't shoot themselves in the leg while trying to protect what's theirs. One of those mistakes would be dumping a lot of information into one mark. I've seen um, a client wants to register names as one, so to you with a logo, place their names, different names on that mark. When you explain to them that the idea of registering a trademark is that it has to be unique and it must stand, they have issues because probably they might have registered the company in that name and they want that trend to continue. So one of the mistakes is that they lump a lot of identifications in. That's one. Another mistake I've noticed is how they add slot trademark. They are very taking it out because it resonates with their brand. It's important for what trademark seeks to protect a name or a logo. It's as simple as that. The simpler your mark is, the better. Because the idea is when you have a creative name, you are able to identify when somebody has copied or has your mark. But when you use sentences in a mark that are available to every other business, to every other brand, a person who is smart enough find to be found your brand name that may sound and look like it, but will not be simply because it's a popular term being used. So if clients would understand, the simpler it is, the shorter your trademark name, the better.
Okay, so my next question is, can a client register a trademark by themselves, or do they actually need a trademark attorney or law firm to be able to do that?
Well, the answer is yes. A client can register a trademark by themselves. Remember, I said earlier that in registering to be able to file trademarks on the platform, there's an option of registration as an agent, and there's another option of registration as an individual. When you're registered on that platform, it means you can now file and register your own marks, just like is everybody's fundamental rights to represent themselves in court. Every
Yeah.
individual can also register their own marks themselves. The question is whether they are professionally experienced and all the technicalities involved in registering a mark. Like I said, it's possible for a client, an individual, to file their own marks themselves, just like they can themselves in court. They also have that right to file their marks themselves. The platform allows it if they are duly registered, but what's important is whether or not they have knowledge around intellectual property. In my experience, IP law is a very technical area. Some concept might look simplified enough, but then when you start going into what is registrable, what is allowed, having conversations with examiners, then you see that there's a technical aspect of it. As soon as they are able to satisfy that they have the understanding of what it takes to be able to file their own marks from start to finish, then they are able to proceed and do that on their own. But my advice will always be to seek out not just a lawyer, but one who has knowledge around intellectual property.
Interesting. Not just a lawyer. So
Mhm.
my my next question is as to how long it takes to actually do a trademark registration. Because I've had conversation where someone is like, it's not trademark. 2 weeks, pata pata, your certificate is ready, and I'm like, is it not this person actually that is supposed to do opposition? So I'm just
Exactly.
thinking, how long I mean, because you have these people who keep shouting their name and saying, I'm an agent, you can get it in 2 weeks, you can get it in 1 month. So for instance, let's use the August Avenues case where he said he had done the registration and then we found out that all he had was the acknowledgement, the acceptance. And then questions as
Yes.
to whether that was suffice as a certificate. So how long does it really take for one to get trademark certification in Nigeria?
I said on paper is about 18 months.
Okay.
That's on paper because what's involved in trademarks is I think there are two phases of the application. There's the phase of search up to the acceptance letter, and then there's the phase of publication up to certificate. Is at first to find out if your name can be filed, if it's accepted, the law qualify for before it is filed. Once you do that and you search in a particular class and the name is not taken, then you can proceed to your trademark. The moment you file your instant acknowledgement letter saying application, and then that is reviewed by you are issued and accepted. If it's not, you're issued yes. So that ends your journey to find that trademark class. But if you get an you now proceed with publication. So the journal where it publishes.
It has this journal that is published 3 times a year.
Yes, a trademark journal that is published every quarter. Every quarter, they publish a journal of the mark out in the preceding quarter. So ordinarily, the trademark registry is supposed recently filed and accepted trademarks once every 4 months on their journal. What that means is that as soon as you file your mark and is accepted, you should expect your publication in 4 months.
Okay.
As things should be. But over the years, they've had issues with backlogs. So we'll find out there's already a queue waiting for their marks to be published. And so when that happens, it delays the outcome of the publication, which is why I said on paper it should be 18 months. But all things being equal, your mark is supposed to be published in the first quarter of you filing it. What that
Mm.
publication does is that it gives the public notice that a mark is about to be, you know, trademarked.
Right.
And so they are giving room to send in oppositions. If there's anybody who has a similar mark or who believes the mark should not be filed because it offends.
I said, yes, let's continue from the defense for opposition.
Yes, so they are giving 2 months from the time of publication to send in their oppositions and their reasons why they believe the mark should not be filed. If there
Mm.
is any opposition, then the applicant is allowed to defend the mark and all of that. Is completed and the registry deem it to proceed to file that trademark, then they will continue and then issue it to client. All of this is expected to take between 12 to 16 months on paper.
I
But
like how
then
you
in
keep making emphasis on the on paper. We
yes,
really need
but
to
then in
keep.
practice, it's important that, I mean, clients and lawyers should also understand that what's obtainable in theory is not the same in practice. For
Mm.
instance, the trademark platform is supposed to run independently. What that means is that once you mark, the computer
Mm.
is expected to review whether you put in a search, in it, accept it, and the next time you're logging into your should be you getting an
Interesting.
system is set up in such a way that it was supposed to eliminate any human conversations and contacts. As soon as
Mm.
you file your mark, the platform is supposed to give you updates. And the next time you log in, you're supposed to be checking for your acceptance letter. Everything should be happening on the platform, right? But in practice, you have to reach out to a person who is in that you filed the mark so they can check it for you.
Mm.
Ordinarily, as soon as you file a mark, the computer is process that filing till the end and then give you feedback whether or not your mark has been accepted. But in
Mm.
practice, what they have tried to do is they try to eliminate physical trademark filings. A few years ago, all marks used to be filed by hard paper in person. You take your application to the office and printed, and then acceptance letters are issued in hard copies. But then
Mm.
let's now digitalize all of that. So both acceptance letter, acknowledgement, those can be gotten as soft copies directly from the platform. But the pace
Mm.
between filing your application and getting that acceptance letter always requires
Always require what?
a middleman, somebody in the office who would be personally informed about your mark,
Mm. Mm.
about your application.
Okay.
So that in a way has obstructed how seamless the procedure is supposed to be
Should happen.
because yes,
Mm. Will I say that's a Nigerian factor, or we just
definitely
take it as is?
definitely is a Nigerian factor. As much as we try to digitize a lot of things, there are still human
Mm.
beings who play a role in it, and this particular has made it impossible to act without that middleman playing one role or the other for you in the background.
Let's hope that one day we get it right and we all have a seamless registration.
Yeah, hopefully.
So I'm going to ask you a couple of questions around procedure for registering a trademark, but you've answered that while talking about how long it takes to register, then talk about
Okay.
acceptance stage, rejection. But let me just get straight to the next one. How can one get a copy of the journal? Is there like an e-copy for it? And what recommendations would you give to the registry on how to make trademark registration a bit more easier for individuals and corporate bodies and lawyers?
Okay. To my knowledge, there are no e-copies. As a matter of fact, to see the journal, you have to physically make your way down to the registry. And then
Mm.
it's like the book of life. A staff to you, and then you both scan through it. In fact, sometimes it appears no eyes can see the book of life except a staff of the registry.
Ah, serious issue.
The journal has been made really
Mm.
tasking by the agent, by the registry. Is
Yeah.
online, and to find your mark in it, you have to make your way down. I said they treat it like the book of life, and only those who are worthy can open and look at it. So most times, you find a copy of the acceptance to there, who would now
Yeah.
look through the maybe send where your mark has been published to you and all of that. So I believe one way they can make it easier for everyone is to make a soft copy of um, that publication
Yeah.
of the journal. It's
Mm.
important because
Mm.
they have the data of both the agent and both the client. When you file a mark, you fill out your email as the agent, email of the applicant itself. So if there could be some form of newsletters at the application stage, they have both emails of the applicant, who is the client, and the agent, who is the lawyer. So it wouldn't be bad and it wouldn't cost anything if once the publications are in, they send newsletters to the email list, and let everyone who has filed the mark within the time frame have in their inboxes copies of these publications. Send it to, and that way once they look through, they are able to know when they are published and proceed to the next level rather than coming all the way. Some people file marks from Lagos. You will not expect a client who is based in Lagos to come all the way down to look through a physical journal because they have filed the trademark. So if that is
Yeah.
done, it makes it a lot easier and both lawyers to move through the rigors of knowing whether the mark has been published. And that cuts off any middleman and whatever hours and time wasting that might come up in that particular phase. So I think that's one way that they can improve. And that's one challenge done is facing currently.
Fantastic. Thank you for that wonderful recommendation. So I was going to ask you again. For so we just had a call to a few days ago. What recommendation would you give to the lawyers that are just called that want to be trademark agents, or lawyers who have been practicing for years and want to delve into IP practice to become trademark attorneys? What would you say to them in terms of getting into this particular kind of
I mean, like every practice in law, interest, getting information. For new lawyers, in that area of law, it's still emerging. A lot of clients don't even understand what it means, but it's something that could receive more attention if a lot of lawyers are learning and studying around it. So for starters, any lawyer, new or old, who is interested in making a career part of intellectual property and trademarks should first start by information. There are other lawyers who are doing a lot of research work in the area. Of course, you, Rita, you putting out a lot of content and information on intellectual property. So I recommend a new week
Yeah,
to start from
keep it
reading.
on.
Of course, I recommend that all new weeks who are interested in intellectual property should start by following you. I believe cut out a year's learning if they just follow you and read up your content. You've done a lot of work in building information and knowledge in the area. But beyond that,
Thank you. Thank you. Thank you. But beyond that,
yes, I said beyond getting the information and reading about the area, understudying other lawyers who are in practice of intellectual property would help them a lot. Because as much as you read about filing a trademark, when you get into the process of navigating your way through that platform, you have actually done it. And after a while, you can now pick from there. So get information about intellectual that's following lawyers who are already writing, researching, and reading up on the area, and then understudy somebody who is actually in the practice of advising clients, filing patents, drafting claims, and everything.
so that's a very good career advice for anyone wanting to become a trademark attorney like Derek.
Yeah.
But what trends? What trends would you say you've seen in the during in the course of time for trademark? What trends have you noticed? Is there a particular area that people are tilting? Uh, what do we really need to know about the trademark industry? In all of these
Yes.
years where you've been a trademark attorney, what trends have you noticed in all the applications you filed? Is there a particular industry that people are tilting to so that who to will go and register and wait? Or what do we necessarily need to know about trademark trends in Nigeria?
Well, from my experience so far, I would say that the tech. I said so far I've noticed that because there's a lot of surge in the tech space in Nigeria, a lot of tech savvy people are building brands, building products, setting up systems. They are now getting information about trademarks. And so most of the trademarks that are filed in the past years, the majority of them have been around technology services, building of software and hardware and products, because of how global technology is. Any brand can start out here in Nigeria and they're already serving people in the US. So they now understand the need to have their name saved and secured before they even start building what they are building. And so most of the marks I've seen, particularly in that technology area. Secondly, most brands, uh, most trademark protections have been mostly for services and less of goods. It's as if of the 45 classes available in trademarks. Yes, I've noticed that it's mostly the classes in services that have most traffic for trademark filings. Most people who sell goods don't, find it needful to register a trademark, but those who provide services, because there are a lot of competition in hoteling business, in recreational services, legal services, a lot of areas of services and service providers in Nigeria. So that particular industry has taken a lot of traffic in trying to protect their names and their trademarks, in my experience.
Wow. So that means we need to do a lot more sensitization for people who manufacture goods. Or do you think this has anything to do with the import and exporting uh, industry?
Uh, well, I think it has more to do with the outbreak of entrepreneurship in Nigeria.
Okay.
It's now very clear that most Nigerians cannot depend on their salaries for survival. So people are branching out to have their own startups, small business. When a business is starting, so does an idea, a concept, and a name to identify that business. And so as soon as you register their businesses and companies with CAC, the next question is your brand. And so I also give it to lawyers who have done marketing and sensitization to let these upcoming businesses know that beyond just registering your business or your company, there's such a thing as protecting your brand and trademarking it and protecting your name and your logo. And so far, a lot of clients have listened and they have taken steps to protect their brand beyond just registering their business and their companies with CAC.
So I like that you mentioned CAC. Between CAC and the trademark registration, which one should come first?
If I answer this question how it is in my mind, I'll be in trouble. But then I think it depends on the goal of the client, which is why every time I'm giving an advice to a client, I try to understand the idea behind what. For some clients, they are satisfied with just having the business name and the company name, and it's nothing special. It's like every other day, every other name. When that happens, sufficient enough to register your name and your company with CAC for the purpose of standing right with the government, pay your taxes, being available for official contracts, and just being on the records in case somebody wants to do a due diligence on you, right? But when a person has a name that they are attached to and they are building a brand and they are building a system that might expand, sometimes they might not even know it at inception. So I always give them that advisory. For instance, you're registering this company as maybe a general merchandise company. So you're not even sure all of the industries you might expand to in the future. That's why you registered the
Yeah.
company. But in the long run, when you have a brand, you have taken not just an identity in the market, but you have taken a title. And so it's important that even as you register your company, you should also register your trademark. If there's one that is more important than the other, I would say
That is more important than the other. You pick.
yes, it will depend on what the client wants.
Uh,
Yes, but I would say for every client who is starting out a business, a new business, it's important to register your company at the same time register your trademark. There are different things and they offer different things. For instance, you may not be able to have a corporate account by just registering your trademark, but you can if you register a company name, right? So you see there are different advantages. So I advise a client not to register a company because he wants to separate the company's money from his personal income, and that will require properly registering a company with CAC so that you have all the documentations to be able to have a corporate account. But after that is done, the of that brand is dependent on registering a trademark. So if you hope that someday you grow your business to such a height that people want to copy what you do and even want to pass your name off as their own, if you have that vision, then it's important to get a trademark. So the problem with clients not registering trademarks is because they don't have the information of what trademark can do for them. Number two, they don't have the vision of what their brand can be. Clients do not have interest in trademarks is number one, they are not informed of what trademark is and can do for their brand and business. Number two is that they don't have a vision for what their brand can be in the future. Because if they
yeah.
do, they will go ahead and protect it now that it's not famous and popular. So that on a big day when somebody wants to pass off on their hard work, then they could have proper protection to seek some kind of remedy against them. So those are two of the challenges, and this is why um, most people are not interested or not even know about trademark. So what I do in my practice is that every time somebody talks about a brief to register a company, I give them the advisory for both the company and for. So what I do to clients is that when I brief for the company registration is good for the company and then trademarks, because most of them might not be aware. So I explain in that advisory what benefits they get from also registering a trademark, and then I recommend what classes. So I do that in them and to help them decide the trademark as they register their company. And most times, okay.
Just to ask you,
Okay.
even though it felt like you gave us a politician answer, you just told us what we should do and what we shouldn't do. But I think everyone has gotten the hint. But how do we now maintain this
Okay.
our vision and goals? How do we maintain our trademark after applying for it and getting the certificate?
As soon as your trademark is accepted and your issue, the lifespan in Nigeria is about, is it 7 or 10 years? I'm trying UK's jurisdiction.
7 years for
Get a certificate. The trademark is valid for 7 years. 7 years, you can always pay. The beautiful thing about trademark is that it never expires. Once it's your trademark, it's always your trademark as much as you are willing to service this needed to be paid to keep functional and working. So that's how to.
Is this
of course
after the first 7 years? Is this yearly or after the first 7 years?
After until after.
Then we start paying the renewal fee.
Then you after the first 7 years.
What is renewed again? I said the renewal is after
the trademark.
Okay.
Yes.
Okay. Thank you for that clarification. So, just to wrap up, any final words for listeners about trademark, about anything related that you want to share for us? Maybe it's business law or IP related, and then tell us how we can reach you in future. If we want to bring you back here, or if we want to slide into your DM for consultation, how do we get across to you?
I'll say in closing that is important for
both lawyer
clients to get more information on intellectual property. It's still an area that's evolving. There are a lot of new things coming up every day. Ask questions and get interested, because the more creativity we'll find in Nigeria, the more need we have for intellectual property, because of course beyond going into the whole nitty-gritty of what intellectual property does and protects, it's one of the safety nets that creative people have that won't be protected. So I believe we can expand in a lot of it. It's really an interesting area. So to reach me, I think I respond faster to my emails and my WhatsApp messages. My email address is. If you write a book, if you publish a book today, and that book has a title, the title is not something you should trademark. Of the book and the content is subject for copyright. If you have an NFT collection and you give it a name, the moment you some copy of that collection with the Copyright Commission, you have protected both the title and the contents of that collection. So until we get to that sophisticated trademark filings, copyright is sufficient protection for NFT.
Wow, thank you so much for that insight. Thank you. Thank you for coming on to speak to us, despite all the bitch that we had. Thank you for being very patient. So this is not easy. I really appreciate it. I learned a lot. Thank you. Hope you had fun, despite all this back and forth.
Yes, I did.
Yeah, so hoping to bring you back some other time, but thank you so much for today.
Hello, IP friends. We have come to the end of today's episode. Super thank you to everyone who has listened to me. For our guest for today, Derek, thank you so much for being very patient and kind with us. Despite the network glitches, we're able to successfully record this episode. So if you hear any background noise or echoing, is as a result of the network. We're trying to manage it. This recording took us more than, I think, about 2 hours, which is more than my normal time for recording. But yeah, thank you once again, Derek. I do appreciate you coming on today to talk to us, and congratulations to our winners, Choma, James and Amara, who participated in the IP series Christmas edition IP game. Let's look forward to bigger deals next year, and have a fab holiday, guys. Love you guys. Bye.